Rights Amendment. In 1972, Congress sent the Equal Rights Amendment to the states with a 7-year deadline for ratification. In January, 48 years later, just down the road in Richmond, the Virginia General Assembly became the 38th state legislature to ratify the E.R.A. That number, 38, is important because it is 3/4 of the states. Because this happened here in Virginia, and we're Virginia's flagship university, it seemed proper that we should talk about this. Even more so because we have among our professorial ranks some of the world's top constitutional scholars on topics, including, as luck would have it, amending the Constitution. With E.R.A.'s symbolic victory on many questions about amendments and time generally, Congress and the states, and whether the E.R.A. as written in 1972 would have its desired effects in 2020 and beyond. This topic touches on many interesting areas of law, both procedural and substantive, and both professors have free rein to take on this topic in as broad or narrow terms as they would like. One note, I would like to mention this is a topic. It would be really good to have a female voice on this in this discussion. Because of the timing, we wanted to have this done before spring break. It just didn't quite work out that we were able to make that happen, but it is something that we are cognizant of. On that note, though, let me introduce the panelists that we have. Kim Forde-Mazrui is the Morton Ward M. Kaplan Professor of Law, Earl K. Shaw Professor of Employment Law, and the Director of the Center for the Study of Race and Law. His scholarship focuses on equal protection, especially involving race and sexual orientation, and he teaches constitutional law, employment discrimination, criminal law, and employment discrimination, criminal law, and racism law. He received his AB and JD from the University of Michigan Law School, which I guess makes him a double Wolverine.
Double blue.
Double blue.
Instead of double blue.
So watch out. I guess if it's not a double Wolverine, you don't have to watch out. But, after law school, Professor Forde-Mazrui clerked for Judge Cornelia Kennedy. He recently wrote an op-ed in the Richmond Times-Dispatch entitled "A Liberal Case Against the Equal Rights Amendment." And then Saikrishna Prakash is the James Monroe Distinguished Professor of Law and the Paul G. Mahoney Research Professor of Law here at UVA. His scholarship focuses on separation of powers, particularly executive powers, and he teaches constitutional law, foreign relations law, and presidential powers. Professor Prakash is a graduate of Stanford and Yale Law School, and he clerked for Judge Lawrence Silberman and Justice Clarence Thomas. Among his more than 75 law review articles is Of Synchronicity and Supreme Law, which explores time as a constraint on federal lawmaking, and it's a very good article if you haven't yet read it. So thank you to both professors for sharing your time and your insight with us today. It's going to be very informal, this conversation. Professor Prakash is going to start with a few remarks, followed by Professor Forde-Mazrui. We'll end at 1 p.m., and there'll be a few minutes left before concluding for questions. With that, I'll turn the podium over to Professor Prakash.
Well, thanks so much for having me here today. I'm very interested in hearing your questions and hearing what my colleague, Professor Forde-Mazrui, has to say. I'm not really going to speak to the policy behind the E.R.A. I favor the E.R.A. I kind of believe that the court has already kind of done the work of the E.R.A. In large measure, if not entirely. And so it's really sort of a more intellectual question for me than it is a practical one. Having said that, I understand it's a symbolic question or an issue for many, and of course it has to be understood as such. So I'm just going to talk about the process and not the substance. And the process for amending the Constitution is laid out in Article 5. Formal amendments, or at least, are laid out in Article 5. We've had many informal amendments. But the formal process, we either have Congress propose amendments or we have a constitutional convention that's called by the states to propose amendments. We've never had a constitutional convention since Philadelphia to propose amendments. And so all our amendments, all our forms have come from Congress. And the process for 200 years is that both chambers have to pass an amendment within a 2-year period, that is to say within a so-called Congress. And this Congress sort of begins at the beginning of the year and then ends 2 years later. And if you go online, you can see that we're in the 100 and something Congress, right? And they're all 2-year periods. So every amendment's been generated within one of those 2-year periods, not across 2 Congresses, not across 3 Congresses, and not across 4 Congresses, or for that matter, 50 Congresses. And if the Senate passed an amendment and the House did not within a Congress, then in the next Congress, the Senate had to repass the amendment, right? And that's true for the House as well. And so if you look at the 17th Amendment, the House passed it repeatedly, 3 or 4 times before the Senate finally said yes. And they did that because I think they presumably understood that they had to. So that's the practice of proposing amendments. What about ratifying them? Well, I think until 3 decades ago, all amendments had been ratified by the states shortly after they were sent to the states by Congress, A. B, within several years after being sent to the states by Congress. And I talk about this in the article. I don't remember the exact, since I haven't read it. This is the article. So if you want to look it up, please do, and you'll be one of the few people who have read it, one of the treasured few. I think almost all amendments have been ratified within the scope of 3 or 4 years at most. There hasn't been an amendment ratified over a longer period of time until what? Until the 27th Amendment. The 27th Amendment, it will be found in your pocket constitutions and in your case books, and it relates to pay. It relates to how Congress grants itself pay increases. It was proposed as part of the Bill of Rights, one of 12 amendments sent to the states. You know that 10 of those amendments were quickly ratified. 2 of them were not. One of them that wasn't was the pay amendment. In the 19th century, the pay amendment was thought to be dead. How do we know this? Because states that didn't ratify the amendment had missives sent to Congress asking them to repropose the amendment. That is to say, the states that could have ratified the amendment in the 19th century instead asked Congress to repropose the amendment. And so you see actually discussions in the 19th century saying, we need to revive this amendment, not by ratifying it, but by getting Congress to repropose it, and then we can then ratify it. And there was a state in the late 18th century that purported to ratify it, but it was sort of mocked for doing so, and the argument was, this amendment's dead. You can't ratify it 80 years after the fact. It's been long dead and buried. And as recently, I think as 1987, people were still proposing the pay amendment within Congress. That is, members of Congress were reproposing the 27th Amendment, thinking that the Congress had to be enacted. That all changed because I think a enterprising student found out about this amendment, read the Constitution, concluded that there was no restriction on ratifying an amendment, and wrote a paper, I think got a C on the paper, on the thesis. But he went to the states and got them to ratify the amendment. And eventually 38 states did. And then members of Congress said, we support the amendment. And both chambers declared that it was ratified, and so did the Office of Legal Counsel. And so you had a confluence of 3 branches saying it was ratified. I think it was, there was a bandwagon effect with respect to this amendment because no member of Congress wanted to be on record as saying, I oppose an amendment that limits my ability to raise my own pay. If this amendment had been about abortion, either way, either pro-choice or pro-life, there's no way there wouldn't have been a controversy about whether or not it had been ratified, because the previous understanding was long-standing and uniform that amendments had to be ratified within a time period shortly thereafter proposal. And that's why people talked about this amendment being dead and having failed in prior years. And that's why people were proposing the amendment again, because they thought they had to begin from ground one. And we all have this sense, right, that some things have to begin over again, right? I've told you about the proposal process. That's always been done in 2 years, and if it's not done within 2 years, you repropose it. But that's no less true for statutes, right? We don't today say that a bill passed by the House in 1789 can be acted upon by the Senate today, and then without further ado sent to the president. So there's always been a sense, I think, of there's some need of synchronicity or contemporaneity. But the 27th Amendment just sort of blew past all that, and again, it's in your casebook, and so who am I to say that it shouldn't be there? It's there. So what happened, I think, is that those folks who favored the E.R.A. looked at the 27th Amendment and said, you know what? Maybe the E.R.A. is still alive. Even though there are books saying it's dead, maybe it's alive. And they had different sort of opinions about why it would be alive. One would be Congress can't impose a deadline on ratification. So even though the E.R.A. originally had a 7-year deadline and then they extended it 3 years, those deadlines were null. And as such, they had no legal effect, and so this amendment is still out there to be ratified. That's one sort of theory. Another theory is that Congress can just extend the ratification retroactively, even though the expiration of the ratification period expired several decades ago. They can just go back in time, or go back today and pass a new resolution and just change that. And that's what the House did recently. The House passed a resolution to lift the restriction on ratification. That would require, if it's valid, it would require the Senate's consent. You might wonder whether it requires a 2/3 supermajority to change the ratification period, and that's an open question. The original E.R.A. came with a 7-year ratification that was adopted by a 2/3 majority vote. The way the E.R.A. worked is the E.R.A. had text, but it was embedded in a resolution. The resolution specified 2 things. Who would ratify the amendment? They said state legislatures, not state popular conventions, because there's 2 alternatives to the Constitution. And it specified the 7-year period. Both specifications were passed pursuant to a 2/3 supermajority. When they extended ratification, they did it by majority vote. They did not give 2/3. So there was this question about whether the ratification, whether the extension was valid. It ended up not mattering, at least in the short term, because the 3 years came and went, and they couldn't get sufficient ratifications. So again, if you think that you can now kind of go back and extend ratification, then the House is doing something meaningful. When I wrote this piece, I have this section at the end on the E.R.A. I just kind of thought the House was just going to say it passed, right? That the deadline is invalid. See the 27th Amendment. Not quite right, but you could argue that it's still. You could think that deadlines are unconstitutional. I don't think you can cite the 27th Amendment for that proposition, but you could think they're unconstitutional. And if you thought that, then you wouldn't need to change any statute, right? You would just need for the House and the Senate or the political branches to kind of agree. And that, of course, raises a question, right? Well, who decides this matter? And the Constitution just doesn't say. It doesn't say that the president decides whether an amendment's properly ratified. It doesn't say the Congress, doesn't say that the courts get to decide this. And the president, the executive branch, in an OLC opinion thinks it decides this question. And I think there's a good case that Congress decides this question, because Congress is the one that starts the process. The president doesn't have any role in the amendment process. Amendments don't need to be sent to the president for a signature. So the case for the Congress is stronger than the president. And that being the case, maybe Congress, the House could have just said, we think it passed, and waited for the Senate to act. And if there's no contemporaneousness requirement for ratification, I don't know if there has to be a contemporaneousness requirement for signaling validity of an amendment. That is to say, the Senate might agree that it passed 10 years from now. And if you have the view that amendments can be ratified over centuries, why can't you decide whether it's been ratified over decades? So that would have been better. They didn't consult me. I don't know why they did this, because I think there's no chance the Senate's going to pass this resolution. At least they could have been on the record as saying it passed. Now they can't say it's passed until they pass a new resolution, right? Because until both chambers say it, they can't really say it's passed, given what they've just done. Now they could change their mind and go back and just say, we think it's passed. What we said before was wrong, and now we think it's passed. I have no idea. Right? I don't know why they would do what they did. It doesn't, I don't think it's in their interest. Their interests are to say that it passed. And the quickest way to say that it's passed is to say that it passed, and not to try to amend this resolution. You're better off just saying, I think that it's unconstitutional. I think that's a weak argument, but I don't think it's any weaker than trying to retroactively revive the amendment, right? To go back and say we're lifting the restriction, because you have the problem of the restriction is 40 years old, and the ratifications are that old as well. And they were given in a context where the states were told this was going to be decided in 7 years, and as you probably know, some of the states have rescinded. So I don't know what's going to happen. No one can tell the future. I don't think the Senate's going to take up any resolution. I suspect that some litigants will try to argue that it's been ratified, and then the courts might be dragged into this question. What they will do, I do not know, right? Because the political branches haven't said something definitively about whether it passed that they can then hang their hat on, they the courts. You might think that, that they'll decide this question. You might think that they won't. Coleman versus Miller is a case where the court suggested that where Congress doesn't impose a restriction, the courts aren't going to enforce any implicit restriction that's found in the Constitution. This is a slightly different case because here Congress imposed a restriction in the resolution accompanying the amendment. It's not itself part of the amendment, but it's part of the resolution. The resolution also specifies who gets to ratify. If the resolution accompanying the amendment has no legal force, then neither does the part of the resolution that specifies who ratifies. So I think it's a wonderful mess for us to puzzle over and to enjoy, and you can puzzle and enjoy greatly as you enjoy the pizza. I look forward to your questions, and I look forward to what my colleague, Professor Forde-Mazrui, has to say.
Thank you for being here. Thank you, Connor, for arranging this. And again, we had discussed some feminist scholars. I'm afraid I can't substitute for a woman, but people think I am sometimes because in correspondence my name's Kim. I have a hyphenated last name, and my father-in-law doesn't think I'm particularly masculine. But I actually do oppose the E.R.A, and being a man, that makes me especially in need of explaining myself. I'm coming at this from my my scholarship on race, where I believe that strict scrutiny, which I believe is what the E.R.A would do for sex classifications, does more harm for racial equality than the intermediate scrutiny that that sex currently gets. So the title of my remarks are Why the E.R.A Could Harm Women's Equality, Lessons from Race Law. First of all, just to identify some practical equality concerns, so you can think about kind of real world situations that, that motivate supporters of the E.R.A, and whose goals I support as well. Equality in the employment setting, including things like or persistent inequality. Addressing issues of pay equity, promotion, support for parenting, both maternity leave and childcare, as well as concerns over sexual harassment. There's concerns over representation of women in various educational fields, especially STEM fields and medicine, and also the representation of women in business, higher management, business ownership, corporate leadership. Also concerns over violence, sexual assault, rape, domestic battering, are all things that they hope the E.R.A can help to address. And then two more general concerns or desires are for entrenching equality into the Constitution for women in a way that would be more stable than relying on Supreme Court interpretations of the Equal Protection Clause, and also the recognition that comes with putting sex equality in the Constitution. And my claim is that while the E.R.A. Will advance some of these goals, it won't do so that much over current law, and that ultimately it could do more harm than good. Let me read you the text. Section 1, equality of rights under law shall not be denied or abridged by the United States or any state on account of sex. And then Section 2 is the enumerated power for Congress. The Congress shall have the power to enforce by appropriate legislation this amendment. And I want to discuss first its direct effect on government or state action, because that's what it primarily does. To remind you, it says, shall not be denied or abridged by the United States or any state. So its operative effect, its direct effect is on government law and government action. And in that context, I want to talk about, in some ways, the good, the bad, and the ugly, and then I also then want to turn to the indirect effect for discrimination in the private sector that would have to go through legislation. So in terms of the direct effect on government, the good, it would prohibit state discrimination against women, absent a compelling interest under strict scrutiny, which, because that's usually prohibitive, I'll just use the shorthand of it prohibits sex discrimination. So it would prohibit any government institutions from discriminating in pay, from discrimination in promotions, from harassing women. In educational settings, this would prohibit discrimination in education from elementary school through higher education. It would prohibit discrimination in business opportunities, in corporate leadership. It would prohibit government-imposed violence, whether, at least in the course of a government employee's employment, whether it's a supervisor or a police officer or a military officer. And those are all for the good. The qualification I give on the good is the point that Professor Prakash raised, is that this is already illegal under interpretations of the Equal Protection Clause. I do want to turn to the point of entrenchment by the end, but at least under current law, all such discriminations would be subject to intermediate scrutiny, meaning that it has to satisfy important governmental interests and be substantially related thereto. And the effect of intermediate scrutiny essentially would invalidate virtually all discriminations against women. And it also discriminates against, invalidates discriminations against men if animated by some sort of unfounded stereotype. So those are for the good, but already illegal under current law. The bad, as it applies directly to government, is that it would have no effect on the discriminations and violence and other concerns that go on in the private sector. Any discriminations in the employment sector, whether it's discrimination in pay or sexual harassment, much of what the Me Too movement has been about discrimination in the private sector, which is an ongoing and important problem, but it's one that the E.R.A. does not directly have any impact on at all. That's the same for discrimination in private educational institutions, private businesses. So that's a negative, and moreover, violence is typically done in the private setting, whether it's in domestic situations or otherwise. Some believe that this would allow at least Congress to regulate the private sector violence. It could in the context of, say, employment, but again, it already does under Title VII. You don't need the E.R.A. to protect women from discrimination and violence in the commercial sphere, and it can do so just as strongly as it prohibits racial discrimination. But in terms of purely private violence outside of economic activities, As you may well know, the Supreme Court invalidated in United States versus Morrison the portion of the Violence Against Women Act that prohibits gender-motivated violence. Another lower court case has invalidated a federal law that prohibits female genital mutilation. Following the Supreme Court's lead, both cases relied on the conclusion that private violence or private genital mutilation are not commercial activities, so they can't be regulated by the Commerce Clause, nor are they state-sponsored discrimination when done by private actors, and therefore they can't be done through the Equal Protection Clause, because the Equal Protection Clause only applies to state-sponsored discrimination. Well, again, the E.R.A. would only apply to state-sponsored discrimination, so it's difficult to see why that would give Congress any more power to regulate private violence. And in fact, in the United States versus Morrison case, the court reminded us of the civil rights cases of the 1880s, in which the Supreme Court held that Congress couldn't, through the Equal Protection Clause, regulate racial discrimination. And given racial discrimination gets the most protection, strict scrutiny, that strongly indicates that the court wouldn't give Congress any more latitude to regulate sex-motivated violence, even if the E.R.A. gives sex strict scrutiny. And then the third aspect of government action that, let's see, okay, no, excuse me, I skipped over one. Okay, so that's the bad, that it wouldn't address private sex discrimination. The ugly, the worst aspect is that the E.R.A. would likely prohibit law and government policy from taking affirmative steps to correct sex inequality, to promote sex equality. And this is what draws especially on my race scholarship. And I'll divide affirmative policies into three categories: sex-based affirmative action, sex-neutral affirmative action, and efforts to eliminate, thirdly, efforts to eliminate policies that have a discriminatory effect on women. And there's reason to believe that the E.R.A. would prohibit all of these practices. So with respect to sex-based affirmative action, i.e. where women are helped in some ways by criteria that take account of sex. Currently, because of intermediate scrutiny, affirmative action for women is more allowable than affirmative action for racial minorities, because it only has to satisfy important and substantially related rather than necessary and compelling. And there are cases that have upheld affirmative action for women that clearly would not have been upheld if it was affirmative action for racial minorities. And although the Supreme Court is allowing very narrowly mild affirmative action for race in the, for now, there's reason to believe that the current court would not uphold it, but that they would still likely uphold affirmative action for women. This could include in the employment settings. Affirmative action has dramatically increased women's representation in various fields, especially traditionally male fields like police officers, firefighters, but also in corporate management, both with respect to hiring and promotions. Affirmative action in higher education has increased female representation in various businesses or STEM fields and the like. With respect to business, currently the federal government does provide rewards for companies that contract with female-owned small businesses and require that federal contractors engage in affirmative efforts to recruit and train women. Under the E.R.A., these efforts would be subject to strict scrutiny and probably invalidated, where they are much more likely to be upheld under current law. The second category, sex-neutral affirmative action, what I mean is affirmative action that's designed to remedy sex inequality, but which uses race-neutral criteria. An example in higher education is some universities use economic status or what high school you graduated from as a proxy for race, and the similar notion would go for sex. So in employment, a sex-neutral policy might suggest comparable work, like comparing jobs to see if they reflect similar responsibility and skill, regardless of whether it's proven to reflect intentional discrimination. Just it may have a discriminatory impact. Jobs typically held by women tend to get paid less. A requirement of comparable worth could elevate the women's interest, but it would be sex neutral because it would benefit men who's in jobs that are currently underpaid as well, even if it would disproportionately benefit women. Or with respect to parental leave. So maternity leave might be seen as a kind of affirmative action for women, but parental leave would apply to men and women, as the Family Medical Leave Act does. But as the court said in the Family Medical Leave Act case that upheld it, it was intended to promote women's access to employment because of the difficulty of managing family responsibilities that women tend disproportionately to have, and the requirements of the workplace. Currently, that's only unpaid leave. There are proposals to make paid parental leave to benefit women, but it would apply to men as well. So it's sex neutral in its criteria, but arguably it would be still invalid because there is doctrine on the race law side that holds that if the purpose is racially discriminatory, which includes trying to benefit racial minorities, then it's subject to strict scrutiny, even if it uses race-neutral means to achieve that goal. And there's no reason to think that the court wouldn't apply a similar reasoning. It basically says you can't avoid obligations to treat people equally by using subtle or covert ways of doing it. Think Washington versus Davis. If they could prove that the employment test in that case was purposely designed to keep blacks out of the police department of Washington, D.C., the court would have subjected it to strict scrutiny and struck it down. But only because it was not shown to be intentional did the court uphold it. So many policies, and this would apply even to race-neutral policies to increase women in educational fields and access to business opportunities. And then the third category, policies to eliminate policies that have a discriminatory impact. So right now, government employers can decide, and they're actually required to under Title VII, to eliminate a policy that can't be shown to be sufficiently job-related if it has a discriminatory impact on minorities or women. And the problem is the Supreme Court is increasingly viewing just the elimination of a policy that has a discriminatory impact against a group as reverse discrimination against the group that benefits under the status quo. So in a case called Ricci versus De Stefano, the court said, in effect, slightly oversimplifying, but Justice Scalia made this point actually quite straightforwardly, that to change a test, a promotion test, because it disadvantaged blacks, and primarily only whites and a couple of Hispanics would have been promoted under it. And so to change it, redo it, or redesign it because it's having a discriminatory impact against blacks, is to discriminate against whites. And so the court invalidated that practice. As critical race theorist Henry Lopez characterizes the case, the Supreme Court in Ricci essentially held that, quote, considering racial impact in order to avoid discrimination constitutes racial discrimination. That bears repeating, though the logic induces vertigo. To consider race, even to avoid discrimination, is discrimination. So to paraphrase Henry Lopez, to consider sex impact in order to avoid discrimination constitutes sex discrimination. So I'll just give you two examples in the employment setting. There are two current common practices that have a discriminatory impact against women. One is basing salary on the salary one held in a prior job. So employers routinely ask, what was your pay before? And then they know it gives them a sense of what you're worth and how much they can offer you that would be attractive to you. If you make lower, they're less likely to offer you as much to attract you. Because of discrimination in the workplace and other reasons, women tend to pay lower, so that means they start off at a disadvantage compared to men who were paid higher in a prior job. Another practice that has a discriminatory impact is the policy of prohibiting people from discussing their salaries with fellow employees. This came up in the Lilly Ledbetter case. And I believe, at least under the Obama administration, there was requirements that at least federal contractors can't have such policies. Since it was an Obama policy, I'm sure it's been reversed. And there's some move to ban salary, prior salary as a basis for discrimination. So disparate impact would say, well, you have to change this if you, government employer, has one of these practices or both, if you can't show that it's adequately job related to employ these practices. Well, under RICI, the problem is if employer changes its practice and says we don't allow you to, or we're not going to take prior salary into account, now a man can complain who has a higher salary that I'm being disadvantaged by this. And under RICI, they have an argument. And the reason that E.R.A. would make that worse is currently the reason it endangers disparate impact for race is once the court says that avoiding a disparate impact constitutes race discrimination by government, when government does it, that means it's subject to strict scrutiny. And that's virtually impossible to satisfy unless you can show it's directly required to remedy identified discrimination. But remedying disparate impacts for women would only get intermediate scrutiny, but under the E.R.A. would get strict scrutiny, so again would likely be invalidated. So in sum, the good is that it would prohibit government discrimination against women, although qualified by the fact that that's currently already illegal under the Equal Protection Clause. The bad of it had no effect on the private sector, and the ugly is it would prohibit affirmative efforts to correct for disadvantages that women experience in employment and education and elsewhere. Okay, turning to the private sector where it doesn't directly apply at all, but I'll suggest ways in which it indirectly applies. So the bad is just it doesn't apply to the private sector. So that's the first point about private equal pay issues, private violence issues, as I've already mentioned. But the ugly is it could also have the same negative consequence that the E.R.A. has for government action in prohibiting private entities from affirmatively engaging in either affirmative action or eliminating policies with a discriminatory impact. And that's because of the effect of the civil rights laws that Congress applies to the private sector. So as I've already mentioned in the RICI case, that was a case that involved a government actor, so it was, directly raised the concern over potential equal protection violation. It was a fire department. But Title VII applies to private companies, and the state action lies in the congressional act that requires employers to eliminate disparate impact. And I've already mentioned that there are federal policies that require federal contractors who are private to engage in affirmative action. Well, the analysis would focus on the law, the federal laws, the federal policies, but under the E.R.A., the argument could be made that these federal policies are pressuring private companies to engage in discriminatory behavior. And Scalia makes that point most explicitly in his concurrence in RICI. And so that would be my concern for the effect of the E.R.A. To the private sector through civil rights laws. So two things I haven't addressed are entrenchment and recognition. Entrenchment, I acknowledge that it would create greater stability to sex discrimination getting higher scrutiny than currently under equal protection, and just getting higher scrutiny, period, because although I think it's very unlikely, the greater latitude to revisit issues that depend only on judicial interpretations than if there's a constitutional provision that provides a clear statement of what the constitutional rule is. So I acknowledge that that's a benefit. I would say first, I don't think it's worth the cost to entrench what I've argued is a rule that would ultimately harm women's equality because of the sex blindness that it essentially would mandate. I also think that the entrenchment already is quite strong. It's been almost 50 years that the Supreme Court has applied heightened scrutiny to sex discrimination, and the court tends to be in line with society, and if anything, society is more committed than it was in the early 1970s to equality for women than before. So I don't think it's particularly a serious risk that the court's going to roll back heightened scrutiny for women. But I do acknowledge there's a concern. But again, one, I don't think it's worth the cost. And then I would also add that it's also not worth the cost, given that one could adopt an alternative E.R.A. that would actually entrench a better approach, which I'll get to shortly. Recognition, I respect tremendously the value of recognizing sex equality in the Constitution. So not to minimize it, but I would again say that the message of equality is not worth the impairment of actually achieving real equality that I think the E.R.A. would have. And then I would also say that I am concerned with the position that a group is entitled to equal protection only if they're expressly included in the Constitution. Right now, the Equality Clause only mentions persons. It doesn't actually even mention race. And that has allowed the Supreme Court to, without clearly violating the text, to interpret equality for persons to include race and national origin and sex and sexual orientation, and then under narrow circumstances, it's invalidated laws based on equal protection that affect people with mental disabilities, unpopular groups such as hippies, undocumented immigrant children seeking a public education. And E.R.A. is essentially accepting the position that Justice Scalia held, which was, you have to go to the text as reflected by the original understanding of it, and that, in his mind, only applied to race. This endorses and reinforces that view, and I'd be concerned that the message to the courts and to society, while positive for women, could marginalize other groups who are much less likely to be able to get the Constitution amended, to say, take it up with the political process. You have no constitutional right to equality because you're not expressly represented in the Constitution. So finally, I mentioned alternative E.R.A. that could be better. There are a variety of models that could be drawn on, not necessarily modeled after. People have said we've had E.R.A.s in Europe for a long time. Well, they actually have exceptions. Julie Sook is a law professor that Connor and I discussed inviting. She's written a terrific article called the E.R.A. for the 21st Century that surveys all sorts of Western European countries that have constitutional guarantees of sex equality, but also have expressed guarantees and even sometimes requirements of making exceptions for ways in which women continue to suffer disadvantages. Some even go so far as to have quotas for corporate boards and even parliament, and make exceptions that either allow or require accommodating family responsibilities. France and Germany are two examples she focuses on. And then here at home, we also have feminist scholars Catherine McKinnon, who was here a couple weeks ago, and Kimberly Crenshaw, who have proposed, and it's even available in the Yale Online Journal, an alternative E.R.A. It's longer. I won't read the whole thing, but I'll read the parts that I think are most salient. It would say, equal rights shall not be denied or abridged by the United States or by any state on account of sex, including pregnancy, gender, sexual orientation, or gender identity, and or race, including ethnicity, national origin, or color, and or like grounds of discrimination, such as disability or faith. There's another clause, but let me observe something about that. It not only defines sex in a broader way, it makes explicit that ethnicity and national origin are included in race, but it also says, and like other conditions, including disability and faith, which avoids that concern I raised about marginalizing groups expressly. This still allows for interpretation to expand to other groups that are disadvantaged in ways that are similar. And then the next clause says, to fully realize the rights guaranteed under this article, Congress and the several states shall take legislative and other measures to prevent or redress any disadvantages suffered by individuals or groups because of past and or present discrimination, and shall take all steps requisite and effective to abolish institutions that infringe the right to vote and have the vote counted equally. So again, makes express that affirmative remedies for past or present inequalities are not only allowed, but under their amendment required. So I think the current E.R.A. would be worse than the status quo. Even better, we need an alternative E.R.A. Thank you.
Are there any questions?
I had a question for Professor Prakash, and I guess maybe answering it from both your preferred method of original intent and then also your boss's original public meeting. And the reason I ask is because it seems like both affect how we should interpret the E.R.A. for sexual orientation and other sexes based on biology or identity. And specifically, should we look at the time that the E.R.A. was drafted, so late 70s? Should we look at today, or should we look at the point when Virginia is enacted it, or should we look at the time of ratification? So it could be 10 years from now, so 2030, when the views of each would be drastically different. So I guess that would be a public meeting. And then for you, would you look at the drafters' intentions, or would you look at the states enacting it intentions? And how would you deal with the conflicting views of 37 states, which were in the late 70s and early 80s, versus the one state that was in 2019, which might have a very different view?
Well, thank you for the question. I think I don't have to answer the question because I'm the professor, but more seriously, I don't think the E.R.A. is still out there as a valid thing to be ratified. So I think it is a difficulty. Original public meaning or even textualism, I think, become impossible if you have intergenerational knowledge, because no textualist believes that the words of a statute or the words in the English language, that the words don't vary across time in terms of their meaning. So it's going to be a problem for any theory that's somewhat static in its understanding of meaning, or that ties the meaning to a particular time. I think if you're a dynamic person, a dynamic statutory interpretation, living constitutional person, this doesn't really pose a problem. And so, I think, typically people are living constitutionalists or dynamic statutory interpretation folks without regard to the process that generated the document. And in terms of my approach about intent, I think I wouldn't pay as much attention to what Congress said unless I thought that the people reading the statute would have thought that's what it meant. So it often is the case that what the drafter thinks about the text he or she is writing is relevant to the people who are actually making it law, because they may think of themselves as helping to carry an execution the drafters' intuitions about what the law is. But sometimes that's not true, right? So if you're a clerk and you draft an opinion and your judge just tinkers with it on the margin, I don't think it matters what you think the opinion means. The judge has made it his or her own. So, I think I wouldn't necessarily pay that much attention to what Congress did. I would only pay attention to it if I thought that the people who are ratifying it meant to have a meaning that was at least partly parasitic on whatever is going on in Congress. I think what's really interesting about this amendment is how, you know, it means so many different things to so many different people. And in my, you know, piece, I just say, well, it incorporates intermediate review. Kim Forde-Mazrui, Professor Mazrui, who discusses this, and this is his area, he says it incorporates strict scrutiny. The opponents of the E.R.A. says it incorporates Roe. It doesn't say any of those things. It doesn't say it incorporates intermediate scrutiny. That's something that happened later, so it couldn't incorporate it, right? It doesn't say anything. So it's, you know, it states a very broad principle, and what you make of the principle is obviously open to interpretation. I think Professor Forde-Mazrui could be right that they could use it as a wedge to apply strict scrutiny. I don't actually think the conservative justices want to apply strict scrutiny for sex-based classifications, because they think it's appropriate for the state to draw sex-based classifications, and maybe the liberals don't either. But, you know, that's this current cohort. Future justices can do whatever they want. But that's kind of the good and the bad of the amendment. They don't need this amendment to apply strict scrutiny with respect to sex, right? And they don't need this amendment to have abortion rights. And they don't need this amendment to have intermediate scrutiny. Because we could have any of those things with or without the amendment. So I do always worry about what the courts are going to do with text that's presented to them, but I also recognize that nothing we say here today can bind them to any particular thing.
Kim, if you don't mind, I'm just visiting. Couple of snarky comments and then a question. I hope Mitch Connell's not listening to your lecture. First of all, I think that we could get a perverse coalition to pass this through if we heard what you were saying about it. I hope that doesn't happen. But on just a note of comparative constitutionalism, I don't want Canada to be left out of this. So in the Canadian Charter of Rights and Freedoms, there is an express carve-out for gender-based and race-based affirmative action, expressly in the Charter of Rights and Freedoms. Now, my question is the following. Judge Posner wrote an article in the 80s in which he argued that because of the reality of racial segregation on the one hand, compared to the reality of gender integration in households on the other, that there would be much less opposition to gender-based affirmative action than there would be for race-based affirmative action. My impression is that's largely true. So why wouldn't that be true for the E.R.A.? I mean, you could see a situation where somebody like, say, Ted Cruz, he thinks this is great because it makes it much more likely that someone like his wife will become on the board of directors of Goldman Sachs, and that increases household income for people like himself, right? And they may not care about, you know, working class women, et cetera, right? So you can modulate the level of review of these kinds of things in a way that works very nicely for elite men, right? So I'm not quite sure why. I think it's plausible that it could go the strict scrutiny route, but I also think it's quite plausible it could go the other way because there could be a lot of self-interest involved on the part of elite men to have it that way. At least as long as coupling is in forming of mixed gender households is still the norm.
Yeah, good question. So why would I think it would be strict scrutiny, essentially? And yeah, it's a good point. And as you and Professor Prakash indicate, the court has significant latitude. Most scholars I've read predict strict scrutiny. And in fact, I talked with Catherine McKinnon when she was here, and she now sees the implications of strict scrutiny as negative, and she says that in the Equal Rights Coalition, she's a member of, they scrub strict scrutiny, the words, from all their documents because now they don't want it. When the E.R.A. was first proposed, the implications of strict scrutiny were less clear, that it would harm the minority group. So that said, and I acknowledge that there's enough wiggle room that to the extent the court would see sex classifications, sex distinctions as more legitimate, we'll find a way to uphold them, just like even under strict scrutiny, when the liberals apply it, they're more likely to uphold affirmative action than the conservatives will, even though they say they're both applying. strict scrutiny. I do think, though, it will force them to articulate it more in strict scrutiny terms, even though they may be a little more lenient than they are with race. And that's because my reading of the court's justification for strict scrutiny is, first and foremost, if there's express rights in the Constitution, the default is to apply strict scrutiny. Like in the Second Amendment case, once there's a decision, you have a personal right to own a gun. Same with, you conclude free exercise of religion is implicated, or freedom of speech. That strict scrutiny is the way our Constitution protects express rights. It says it's presumptively constitutional. And then even Justice Ginsburg, in the VMI case, she says, unlike race, sex is not a proscribed characteristic. We don't view it as irrelevant. We celebrate our differences. A community of one sex is not the same as a community of both. But by implication, but we do think of race as not affecting, that we're the same when it comes to race. And so race is proscribed, is prohibited, but she's saying sex isn't. We just kind of strongly discourage it. And then she says, but when it's used for compensatory purposes, we allow it, but we don't if it's reinforcing overbroad stereotypes. Well, that's at least consistent with the point that race is considered kind of almost as if it's express in the Constitution. It's expressly proscribed. Justice Scalia actually views the 13th, 14th, and 15th Amendments as a combination to constitute textual prohibition of race discrimination. So if you actually have sex on account of sex in the Constitution, I think the logic of the doctrine, in fact, intermediate scrutiny is the exception. Typically, once you recognize a right, it gets strict scrutiny. In some ways, yeah, so once it's actually expressed, I think the pressure would be to say, well, now we're going to stop following this kind of anomalous, unusual tier and apply it the same way other express rights are protected.
All right, well, thank you to our two professors for joining us, and thank you all for coming.